as college football season kicks into high gear. Some major decisions made over the last few months could redefine how college athletes get compensated for decades to come. Here's my report.
Let's make a little history tonight in Indianapolis. Jim Nance at Grant Hill right now.
Millions of viewers tune in to the March Madness men's basketball tournament every year, supplying the largest slice of revenue for the National Collegiate Athletic Association, which rakes in about $1 billion annually. Most of that money helps fund athletic programs at colleges across North America, but in recent years, pressure has been mounting on schools to share more revenue with student athletes whose labor has helped turn college sports into a multi-billion-dollar industry.
There are now billion-dollar television contracts. There are many, many coaches, including assistant coaches, who are making more than $1 million, if not closer to $10 million. There are these gold-plated facilities, and all the while, college athletes, their compensation, if you want to call that, has been flat, while spending everywhere else has increased exponentially.
That's Gabe Feldman, director of the sports law program at Tulane University in New Orleans. The NCAA has restricted athlete compensation for decades, arguing such rules were necessary to protect the integrity and popularity of college sports. But this year, a Supreme Court ruling and new state laws have forced the NCAA to ditch some of its old rules, making 2021 potentially the biggest year of change in college sports history.
Oh my God! The most amazing, sensational, dramatic, heart-rending, exciting, thrilling finish in the history of college football.
The push to expand rights and compensation for student athletes has been building momentum for over a decade. One pivotal moment came in 2009 when former UCLA basketball star Ed O'Bannon sued the NCAA for featuring him in video games without sharing a cut of the profits. In 2015, the Ninth Circuit found student athletes are entitled to compensation in the form of tuition for the use of their names, images, and likenesses. Here's O'Bannon talking about why he decided to sue on the TV show Exhale in 2018.
I saw my likeness on a basketball video game. I said, wow, they're still making money off of my likeness, off of my face, off of the things that I did 15, 20 years ago. And I thought that was just...
it's wrong.
It's wrong,
yeah.
Absolutely.
More lawsuits followed, including one brought by former West Virginia University football player Sean Alston.
Alston, you can just imagine this forward lean right here. You thought he was stopped for a
His
second.
suit merged with other cases and eventually made its way to the U.S. Supreme Court.
We will hear argument this morning in Case 2512, National Collegiate Athletic Association versus Alston.
You just heard Chief Justice John Roberts introducing the Alston case during oral arguments this past March. The court issued a unanimous opinion in June, striking down the NCAA's limits on education-related benefits, but it upheld the association's right to ban cash payments and other perks unrelated to education. Professor Feldman told me how that ruling could affect the lives of student athletes for decades to come.
That could lead to significant benefits that athletes haven't been able to get in the past. It could be a better laptop. It could be a musical instrument. It could be any number of things. It also could be cash. You get $1,000 if you hit a certain GPA benchmark or something like that. The cap that would be on those cash payments at this point would be about $6,000. But that's obviously a very meaningful amount of money for most people, particularly for college athletes.
You might be asking yourself, why would the NCAA oppose lifting limits on educational benefits? It's a question I had too, so I asked NCAA lawyer Rakesh Kilaru of the firm Wilkinson Steckloff.
I know sometimes people sort of raise eyebrows at that. Why would you oppose additional educational benefits? And really that came down to two things. First, as the trial unfolded, what the judge eventually said she was going to order, or permit at least, was an additional $5,000 plus in cash. And this was labeled cash tethered to education, but at least from our perspective, it didn't look that different from what had been ordered by Judge Wilkin and then denied by the Ninth Circuit in the O'Bannon case.
Just a quick note here. Kilaru is referring to the Ninth Circuit's 2015 ruling, which held that the NCAA could not limit tuition-related compensation for athletes, but that it could ban cash payments.
I think there were real reasons why the Ninth Circuit said cash might be a concerning thing to provide. It could lead to abuse. It could lead to payments for things that aren't necessarily educationally related. But I would say even more importantly, it could change the relationship of student athletes to their institutions from an educational and athletic kind of hybrid to more of an employment relationship. And that's something that the NCAA has always been concerned about and that institutions have always been concerned about.
One part of the Supreme Court ruling that got a lot of attention was a scathing side opinion by Justice Brett Kavanaugh. The Donald Trump appointee wrote that all restrictions on student-athlete compensation could be illegal. Professor Feldman explains.
Justice Kavanaugh, in his concurrence, wrote one of the more scathing concurrences you'll read and said, although the issue is not in front of me, I'm not convinced that any of the NCAA's rules are justifiable under antitrust law, or at least the athlete compensation restrictions, because if any other industry tried to do this, if Google and Apple and Sony and Microsoft tried to get together and restrict the compensation of their employees, that would clearly be illegal, and in fact has been held to be illegal.
But Feldman warned that people shouldn't read too much into Kavanaugh's opinion.
Although it's striking that a conservative justice like Justice Kavanaugh wrote that concurrence, it's maybe even more striking that nobody else joined that concurrence. So none of the other justices, at least in this case, were willing to adopt that reasoning.
The High Court's unanimous opinion, penned by another Trump appointee, Justice Neil Gorsuch, wasn't a total loss for the NCAA. Gorsuch wrote that the association could still prevent schools from handing out perks unrelated to education, such as a luxury sports car to help a student get to class. In that way, Kilaru says the Supreme Court preserved the NCAA's right to set rules on what is and is not a legitimate educational benefit.
And even Alston recognizes in a lot of places that there have to be some rules and restrictions in place in order for college sports to function. So there's the kind of notable example Justice Gorsuch gave of the no Lamborghini rule. So certainly it's a significant opinion. Again, it's a unanimous opinion, so you have to take that seriously. But I think it's too early to say whether it's a game changer or some kind of broad brush reworking of college sports.
Still, Kilaru acknowledges that the opinion could lead to more lawsuits being filed against the NCAA.
I don't think you can lose a case 9-0 and not think it has to have some impact, even though I have my doubts that Alston is quite as broad as many have interpreted to be. The fact remains there is a Supreme Court decision that at least some people could read to suggest that large segments of the NCAA rulebook are subject to question. And I'm not saying I agree with that, but I'd be a little surprised if there wasn't more litigation over the coming years.
Another major change came this past July when the NCAA, for the first time, started letting athletes make money from corporate sponsorships. The new policy debuted after 18 states passed laws giving student athletes the right to profit from their names, images, and likenesses.
Marketing and advertising can and must rise to new heights.
Most of those laws took effect July 1st, the same day the association rolled out its new policy. Student athletes can now make money by promoting brands on their social media feeds or appearing in TV and radio advertisements. Professor Feldman says this change has opened up all kinds of new financial opportunities for student athletes, and not just those at the top schools who play the most popular sports.
It's a different market than professional sports. In professional sports, you're looking at the major markets in the country. In college sports, it's actually some of the smaller towns, the college towns, the Tuscaloosas, the Baton Rouges, where the athletes probably have more value than they would in New York, because these are such passionate college towns. And whether you're the football player or the soccer player or the swimmer, people want to have a connection with you, and people see you as a way to raise the profile of their business. So we're seeing lots of athletes at lots of levels, both men and women, that are making money off their name, image, and likeness.
The NCAA has always maintained that relaxing compensation rules could turn amateur athletes into paid professionals and threaten the integrity and popularity of college sports. But some critics say the association has an ulterior motive. I asked NCAA lawyer Rakesh Kilaru what he thinks about claims that his client cares more about protecting profits than doing what's best for student athletes.
Ultimately, I would say I don't agree with that. I mean, I think a lot of what's being protected is opportunity. and that's opportunity for student athletes. So obviously folks know that football and basketball generate the most revenue, but there are volleyball players, there are soccer players, there are baseball players, there are all kinds of different athletes who get this opportunity to participate. And a large part of the budgets for those sports are driven by the revenue that's generated by some of these so-called higher revenue sports. So every year the NCAA takes the vast majority of the money that's earned through the March Madness basketball tournament and sends it back to the schools in the form of distributions and other forms of share. And that distribution and those shares then form the vast majority of the budgets for athletic departments that fund all of these other sports.
Killaroo says paying male basketball and football players more than female athletes could raise questions about gender equality and compliance with Title IX, a federal law that guarantees equal opportunity for all genders in public education. Looking to the future, Professor Feldman says we're likely to see more battles being waged in the coming years over issues such as better medical benefits, privacy rights for athletes' data, and lifetime scholarships so those who don't finish college can always come back and earn their degree.
There are many, many other big, if not bigger, issues that are maybe more systemic and more structural that impact college athlete welfare. So I think ideally in a year or two, you'll see college athletes have not only greater rights to compensation, but also greater medical health and safety protections.
Meanwhile, the legal brawls will continue to play out in court. The NCAA is currently fighting a federal lawsuit in Northern California over its restrictions on name, image, and likeness deals. It's also fighting a suit in the Eastern District of Pennsylvania that says student athletes should be treated as employees, paid wages, and given full employment benefits. You can find more coverage of those lawsuits and other cases involving student athletes' rights at courthousenews.com.